Welcome, everybody, to our law school webinar, our last law school webinar of 2023. And last but not least, I dare say, as I hope it will pan out, I'm sure it will. I'm delighted to have my colleague, Dr. Uche Iloka, as our guest for tonight's webinar. Some of you may know Uche. Uche is a solicitor, an academic. He acts as a research degree coordinator in the law school. He teaches a honors module in charity law, and he's a solicitor with considerable practice in charity law matters, and also now is on a board of a charity, acting as a trustee. So he's got considerable professional and academic experience in the subject. So I think we're lucky to have him with us to be able to share his experience and expertise on I think it's fair to say a niche, but an important subject, as I think we'll explain shortly. So welcome, Uche.
Thank you very much, Paul, and I'm happy to be here. And thank you everyone for making time this evening to join us.
Okay, so I think we just start generally. I was looking back at my notes thinking about this. We had a charity law webinar back in 2021, I think it was, and it's now opportune to have a follow-up as we'll be discussing, because there are changes in the pipeline. I think there's been a new act enacted but not yet enforced, but I think that should be in the next 6 months, so far as I understand. But I want to think we'll start in generalities and then move on in a little while to the changes, the pending changes or imminent changes, I guess we could call them. But let's just start in a general sense. Uche, please, maybe if you could just talk about, the role charities play in society, and I think, as we would all know this, about how they're funded, and indeed then in a general sense how they're regulated.
Okay, yeah, thank you very much. I mean, thinking about charity, I would often refer to it as, the third sector. In the UK, there are three major sectors, and as in most societies, you have the private sector, public sector, and the third sector, which often goes unnoticed. But they do some of the most relevant work for the society. It's the only sector, I dare say, it's not driven essentially by politics or profit, but usually by a passion for a cause that is significant to the general existence of the society. And charity law as a whole relates to the rules for setting up and operating these charities. And in terms of how they are regulated, in the UK, there are various key regulatory regimes across the UK due to the diverse UK legal system. In England, in Wales, for example, you have the Charities Act of 2011. The main regulator down there is the Charity Commission. Northern Ireland, you also have a different law, which is the Charities Act of 2008. And all of these laws, like for example, the one in Northern Ireland was amended 2013, and down in England, you also have amendments to the Charities Act of 2011, which was made last year actually, and made some significant changes to the trajectory of regulation itself, which seemingly is sort of opposite to the trajectory of regulation here. In Scotland, we have the Charities and Trustees Investment Act of 2005, which is the current legislation that governs charities in Scotland, and it's been on for about 18 years, and unlike other jurisdictions, it's not had quite a lot of amendments until recently. There was a unanimous adoption of the bill by the Scottish Parliament in June, on June 28th, and then that was now passed into law and received royal assent August 9th of 2023. So essentially, this new act the Charities Act 2023 made some amendments to the 2005 Act, which I'm hoping that we would have some time to discuss. The key regulator for the charities here in Scotland is the Office of the Scottish Charity Regulator, which we often refer to as USCA. And these laws that have been amended or changed is just to empower us to regulate optimally and effectively. The general rule, the common thread that goes across all the regulators is to see how public confidence, transparency, and accountability in the sector can be enhanced. So I don't know if that touches on some of the thoughts that we will be discussing. I'm sure we'll go into more detail as we get on.
Okay, excellent. I just want to pick up on one point there. I mean, it's probably a critically important point. Is public trust that the public can be assured that charities are properly governed and they're safe in donating to charities, or their monies would be safe and not squirreled away to some Swiss bank account or whatever. And then I was just looking about this, preparing for the webinar, and I just Googling this, and about scandals. I did mention to this earlier about just in October 2023. Unfortunately, a chief executive of the charity HIV Scotland is facing embezzlement charges, and you heard that was in the news. And so that's one example, but that's I guess the criminal law being involved, not charity law. But it just highlights to my mind the absolute importance of a robust system of regulation, such that the general public are not wary when donating their hard-earned money to a charity. So that sort of underpins the whole nature of regulation, doesn't it? As you just mentioned, to maintain public trust.
100%. You see, the thing is, within the charity sector, the trade in currency is trust. See, so as your trust capital depletes, everything else about a charity essentially depletes. And that's why it's critical that there is effective regulation of the sector in order to sort of keep that trust capital at bay, and keep it floating, rather than and having the reputational capital of the sector and actors within the sector diminish over time because of practices like this. And that's the reason for these more robust regulations. You see, when you're looking at the responsibilities of ensuring that there's some legal compliance from the sectoral viewpoint to what from the practitioner's viewpoint to what the regulator are saying, two things come to mind. The two underpinning what I say pillars of what charity is, and that is the whole concept of public benefit and charitable purposes. So everything that a charity exists to do must be for the benefit of the public and in furtherance of their specific charitable purposes. And the concept of public benefit and charitable purposes, when they all culminate, you get the whole concept of stewardship. It's how effectively are the trustees, these are the ones who are bestowed with a legal responsibility to manage the affairs of the charity. How effective are they in furthering the charitable purposes for the benefit of the public? And this is the reason why the regulators are there, to ensure that this is the case. So that's essentially it. Now there are a variety. It's something that a lot of people might find somewhat confusing. So there are a lot of voluntary organizations. There are a lot of organizations that are set up for good causes. All right. But what distinguishes these organizations from charities is because charities, for you to exist, to be a charity across the various laws that I mentioned earlier, you have to be furthering one of the statutory charitable purposes and for the benefit of the public. So there is a number of those statutory purposes which all date back to 1601 with the Statute of Elizabeth. And then, of course, the PEMSO case, which now brought a full head in, like the advancement of religion, education, a relief of poverty, and then various other purposes have cropped up since then. So the bottom line of what I'm saying is public benefit, charitable purposes, those two are germane to the effective running of a charity. And that's what the regulators are there for, as a watchdog, to see that these two things are not compromised. And when we look at these changes that are being made to the law, it's also to further safeguard these two concepts.
Okay, and so charitable purposes, of course, are critical. And are they listed or enumerated in the statute? Are they, does
Yeah.
the
Oh, yeah. So
2005
they're
Act?
listed. They are. So, for example, and they're listed differently. For example, in England and Wales, you have about 13 or so purposes. In Scotland, you have about 16 purposes. But when you see they're not essentially different, it's just that in England, they've sort of merged some purposes together. So these purposes are listed. So that's why it's very prescriptive as to what it takes to be considered as a charity, to be registered with the Scottish regulator, the Office of Scottish Charity Regulator. As a charity, you have to pass what is called a charitable test. And the charitable test is to see whether or not you taking one of these 16 purposes, and whether or not you are doing it for the benefit of the public. And when we saying benefit, it's such an abstract term, trying to understand what you mean when you say for the benefit of the public. Sometimes benefits may be clear and simply measurable, but other times it's it's not so. So, for example, where a charity relieves a person's sickness, financial hardship, or improvements in health, these could be classed as tangible benefits. But there are also intangible benefits which are more difficult to measure. For example, the advancement of educational or religion, or promoting the appreciation of some historical buildings. These are a bit more less tangible, but the bottom line is to satisfy that benefit element of these purposes, which are statutorily provided. The charitable purpose must be beneficial in a way that is identifiable and capable of being proved by evidence where necessary, and it's not based on personal views. Okay. And this is something that might be helpful for any practitioner here. In determining the question of public benefit, one of the tests that is being carried out is checking to see whether there is, comparing the detriment or the harm that results from pursuing that purpose as in comparison to the benefit that is received. So what that means, and that looks a bit long-winded, but what it means is if it costs too much for you to provide that benefit, then it might be an issue with the regulators. So where you, for example, your administrative cost or your running cost is not commensurate to the benefit that you're actually providing, then it will be considered that it's costing too much of donors' money to provide such a limited number of benefit.
Yeah, that kind of brings me about to the public benefit. Well, what is the public? I mean, could the public be a very niche, I don't know, supporters of Monty Python movies or some very niche thing? I don't know why I just thought of that, but a very, niche
Yeah.
small number of people, and your charity is to enhance or to expose to the public this genre of a movie or some other narrative.
Yeah. I mean, the thing is that the public part of this public benefit concept doesn't necessarily refer to the general public as a whole. Some charities will potentially benefit everyone in a community. For example, charity was set up for recreational purposes where activities are open to everybody. But however, most charities will have limits on who they benefit. So some might benefit a smaller number of people. Um, and how many people a charity benefits and who they will and who they are will generally depend on the charitable purpose set out in the charities governing document at its inception. Most charities are established maybe to benefit a particular group. So, for example, you could be set up to benefit children in general, while others could be established to benefit children of a certain age. Now, the key thing here when we're looking at the whole concept of public is that to satisfy that public element, the purpose must benefit the public in general or a sufficient section of the public in a way that it does not discriminate. So what would be a sufficient section of the public would vary from purpose to purpose, you know. So a purpose should not generally give rise to more than incidental personal benefit. So that's how you explain it. So incidental benefit is where, you know, it's a necessary byproduct of carrying out the purpose. So when you're carrying out whatever you're doing for the sake of personal benefit, then that is now counter. It's not meeting the whole concept of what it means to be a public benefit. So the charity generally must demonstrate that it's providing public benefit.
Yeah, this is just a random question that sprung into my mind. I don't know if it's relevant or not, but isn't there a debate about private schools in Scotland, and were they charities, and now and the Scottish government wants to bring that to an end? Is that accurate or not? I'm sorry if I'm just sort of just popped that.
No. It's an important point, and again, it's one of the areas that when we're looking at the new law that has come in, there's some areas that were considered missed opportunities for the law to capture, and that's one of which in relation to whether or not charitable status of some private schools should be taken away from them, whether that's some sort of
Sorry about that. We'll maybe come back to that then for something. But I did know, like, that private schools have to have a certain. Well, I think they to meet that requirement, I understand, would offer a degree of scholarships and do other things for people, so they would educate non-fee paying pupils as well as the people that are stumping up all the tuition. Okay, so that just, I know that was a random question I just thought of. Okay, so then we have charitable purposes. I think I understand that, for a public benefit, and then there clearly has to be a sort of rules that formally would govern a charitable organization, like a board and of trustees, which would oversee. Is this accurate? So it's kind of akin to a company, I suppose. Is that this a board of trustees that would have overall responsibility for a charity? Is that accurate?
You're absolutely right. So essentially, the board of trustees are the one who have the collection of people who have a collective responsibility. It's not a several responsibility, it's collective responsibility to manage the affairs of the charity, and would ultimately be liable if they've not acted in the best interest of the charity. And there are several being best practices that have been provided by the regulator. And then you also have the code of governance, which is a UK-wide document. You have the Scotland's Third Sector Governance Forum, which did the Scottish Governance Code for the third sector. Now, what all of this codes as, for example, the Scottish one is premised on 5 core principles in terms of how the board should govern. One is that they should have a clear organizational purpose. So a well-run board is clear about the purpose and the values of the organization and how it would achieve its aim. Also, one of the other core principles is leadership. So a good board is clear about its role and its responsibilities, and it provides clear strategic direction in line with the organization's values and vision. Now, this is very important because sometimes you could have founders of charities that are not on the board, and they get people on the board who are almost like stooges who just do their best to just they're yes men to these founders who don't quite have that direct legal responsibility. But this is counter to what the code expects. So a good board is clear about its role and responsibilities, and provides clear direction. And but again, at this point that I have made, perhaps when we discuss later about some of the changes, we don't that loophole has now been plugged where senior management also have the same responsibilities, almost like trustees. Again, also another significant principle within this code of governance that the board in dispersing with their responsibility is what is called the board behavior. So a good board acts collectively and individually. They embrace there's some mutual respect. There's a question of integrity, openness, accountability, and then of course there's a question of control. So a well-run board develops and implements appropriate controls to direct and oversee the progress and performance of the organization. That's also very crucial. Effective controls, whether it's financial controls and so on. And then the last of this 5 principles is the effectiveness. So the good board understands its roles, powers, duties, and works collectively, proactively to achieve what the organizational purpose is. So there is no distraction. So from what the core purpose is. Now, this is important, Paul, because sometimes if you are a charity, let's say you're a charity set up to, rehome stray dogs, okay, and then you set up a church, for example. That whilst setting up a church would count as one of the statutory charitable purposes of advancing religion, but it is not what you have been registered for and what you've been empowered to do under your governing document. So that would not, so the effectiveness of the board is to achieve what its charitable purposes are, not general charitable purposes. So you must be set up for the particular purpose that you've been set up for, and that's what you should pursue. So in terms of the governance, that's it. But the functions of the trustees, if you look at Chapter 9 of the 2005 Act, sections 66 all the way to 70 gives more details as to what the functions of how a trustee should exercise their stewardship, and the responsibilities of the trustees. They are responsible to provide, the charity's fundraising policy, ensure the financial activity of the charities is carried out, with sufficient care and prudence and skill. They must not put charity assets, at risk or any undue risk. There's a variety of things that we could go down that journey, but essentially it is to act in good faith and act in the best interest of the charity at all times. That's how you steward the assets of the charity. And the assets of the charity is not just, it includes the human resources and the reputation of the charity as well.
Yeah, that's an important point. I guess intangible assets or something. I know some charities have the good name, and this is getting back to trust, I suppose, the beginning means everything.
Yeah.
If you had, I don't know, Clan Cancer Charity or any other, well-known Bernardo's or whatever, well-known charity, their name, their intangible asset. I don't know how you quantify that, but it's worth a lot of money. And what was the famous UN case where wasn't the UN case, but the charity that was working in the Caribbean, and there was cases of sexual misconduct.
Was it the Oxfam case? So, in Haiti. Yeah. So, well, there's several. I mean, there are instances where, and why this is important, safeguarding the reputation of the charity, is because what impacts one charity automatically impacts the sector. So let's say from the scandal with the Oxfam situation some years ago, um, millions of pounds were removed, were redirected from the Oxfam charity as a result of that scandal. But guess what, Paul? I don't think that money went to another charity. It essentially just went out of the sector as a whole. And these are guys, these are people, I mean, the sector, the actors within the sector providing this well needed services to the society. And so the act of one charity somehow has a ripple effect on other charities. So that's why the reputation is of prime interest to the regulators as well.
Yeah, I don't know if the trustees of Oxfam could have done anything about that if it was just rogue characters involved. I don't know enough about the facts of that story. But could a trustee be? You just alluded to this. I think either financially or criminally liable for their consequences or their inaction in their job, or could they be held responsible? Say if a charity owns a church or owns a building, some property, and through mismanagement or it has to be sold, it goes into debt or whatever. Could a trustee be financially liable for the debts of the charity?
Yeah, absolutely. I mean, trustees could have personal liability where they have acted in a negligent fashion and have not acted in the best interest of the charity. And this is why the governance is important. So if the trustees have made a poor decision that resulted in a loss for the charity, but the process by which they reached that decision was really in their estimation in the best interest of the charity, then there's a leeway there. But where trustees have acted in a reckless, negligent fashion, or haven't just attended meetings, if it's, for example, a trustee is not attending a meeting, because the board is collectively responsible. So the fact that you're not there still means that you're responsible for the decisions that have been taken somewhat. So there is some liability for trustees if they have not acted in the interest of the charity. And there's been many instances of trustees being asked to refund huge amounts of money back to the charity because of the ways they have acted.
In
Yeah.
your experience, do charities face a challenge in attracting trustees in light of this possible liability? Or people will be wary of doing that, not knowing, or there's a degree of risk involved in becoming a trustee, I suppose, isn't there?
No, I would say well, it's yes and no. So some people are not aware of the risk involved. Some people are well aware, but they're willing to, if you're there with good intentions, with a good heart, that's half the risk mitigated because you're going to try to do things right. But where there is some ill intentions there, then of course there's your exposure is higher. And there are certain times if you've acted in the best interest of the charity, trustees have trustees insurance, which covers certain liabilities as well. So there is that, but I think the bottom line is whether or not the trustees have acted in a prudent fashion and in a way that furthers the interest of the charity. If the decision turns out not to have been the best, and sometimes acting in a prudent fashion means listening to professionals on a particular scenario. So you're about to purchase a property or something. So you want to listen to the professionals within that sector to tell you whether that is a decent decision. A charity is about getting into some sort of trading. They've done the relevant due diligence, and then they're not going to put charities' asset at risk, whichever the case is. So if you've taken the right steps, then that should keep you in good stand.
Okay, thank you. So if in fact something happens and we have a regulator, the Oscar in Scotland, what powers do the regulators have? Can they wind up a charity? Can they, forcibly remove trustees, or what powers do the regulators have in Scotland?
So the regulators have a number of powers, some of which have been increased here with the new laws. They can, first and foremost, they determine what entities are charities in the first place. Okay, so they could remove a charity from the register. They are the keepers of the register. They are the registrar of charities. They keep the public register of the charities. I'm talking in particular to Oscar now. They can, they encourage, they facilitate, they monitor charities compliance and charities law. They have powers to investigate and if there is some apparent misconduct in the administration of a charity, they can take sort of remedial or protective action accordingly. They can give advice. So there's a principle of proportionality. So you do not use a hammer to kill a fly, kind of thing, because there's also limited resources of the regulator. So a lot of times they sort of provide guidance. That's one of the huge role that they play. And then also they could make proposals to the Scottish ministers on matters relating to the Oscars functions. And in fact, these kinds of proposals that were made in 2018-19 is what led to these developments that we have with the new law that we have at the minute, with the changes to the existing law. So they have those powers. They could issue some negative directions, and currently they can now make positive directions, which so the negative directions are interdictory in nature, where they stop a charity from doing a particular thing or freeze a charity's account or something if they see that the assets are at risk or the trustees are acting in a way that is untoward of a prudent trustee. So so they have a wide range of powers, I'd say. But what we find now with these developments is that Oscar's powers have somewhat been a little bit more enhanced with the amendments that have taken place and now. So we could talk on some of those changes if we want.
Okay, I think now, no,
Yeah.
I think we've set set the groundwork, so to speak, about the existence of charities, I think some of the main features of the 2005 Act. And then I guess the point of our webinar this evening, there's been in the summer this year, the Charities Regulation and Administration Scotland Act 2023 enacted. And that is going to, I think you're telling me earlier, enter into force, plan to have it enter into force maybe in a couple stages next year. And that's making some relatively significant changes to existing charity law. So maybe we could just spend 10 minutes or so talking about those. And then I see there's one question, I should have mentioned this earlier, one question in the Q&A box. Can attendees, if you have any questions on any aspects of charity law, then please do put them in the Q&A box that you'll see, I think, along the bottom of your Zoom screen. And then at the end, I'll read them out to Uche. So please do that. We'll definitely have time for questions. But now we'll move on to this 2023 Act. What are some of the changes? Is it a significant change and indeed more in a more general sense? What direction are the changes taking?
Okay, so essentially the new laws or the changes that have been is to increase the rigor or of the law in pushing transparency and ensuring that Oscar is able to regulate more optimally and effectively, and also bringing it closer to what is obtainable down south in England. And so transparency is one of the crucial things. It's like a recurring theme for us all of the different changes. One of the key changes is for now, there's the inclusion of names of charity trustees on the Scottish Charity Register, and also an opportunity to create a publicly searchable record of trustees that have been removed. So under sections 2 and 7 of this new act, now Oscar has to include the names of charity trustees on the register, and then also keep a record that is accessible by the public of trustees that have been removed either by the Court of Sessions or something. In the previous previous position of the law under sections 3 of the 2005 Act, only the names of the charity its office and charitable purposes were included on the register. But now, and then Oscar was responsible for managing both an internal database, which had the trustees' contact information, as well as maintaining a publicly accessible register that had simply the name of the charity, its office, and the purposes. But now you have to include the names of the charities, and also the publicly accessible register will include individuals that the Court of Session has disqualified from managing or controlling any organizations. So that's one of the key changes. Another significant change, again, to foster this whole concept of transparency and rigor in regulation, is publishing the statement of accounts of all charities in the Scottish Charity Register. Now, this is crucial because previously the Oscar had a guide to charity accounting in 2019, and only copies of the statement of accounts of charities that had an annual income of more than 25,000, or those of the skills. The skills is a charitable form, the Scottish Charitable Incorporated Organization, SCIO. Only the skills and charities with above 25,000 were usually published. But now this amended legislation will ensure that the statement accounts of all charities are sent to Oscar and they are easily accessible by anyone wishing to access them. So this is also another element of rigor and that also would imagine would foster transparency.
And
Another
if I could just interject there, so excuse me, pardon me. And that's an important point. I mean, because one, maybe a public perception or rightly or wrongly, is that some charities would only spend on the actual cause a limited, a relatively small percentage of the donations they get, and their overheads or maybe administrative salaries or whatever would eat up. If you give £1 to a charity, all of that other expenses eat up 75 pence, and so only 25 is actually going to the charitable cause. I don't know if that's fair or that's a public perception. So I suppose that would be discernible by looking at the accounts. You could see what sort of expenses or overheads the charity has as a proportion to the overall donations it receives.
Yeah, absolutely, absolutely. That's exactly the point here. Because if I draw your mind back to what I said earlier about the whole concept of public benefit, that if when Oscar's regulating charities and they look at how much it costs to provide that public benefit, and it's not proportionate, so you find that it's costing too much to provide that public benefit, then there's a problem with that the charity in meeting the charitable test. And this is an element that makes it easier to see how much has been spent in actual delivery of public benefit, or how much has not been spent in furtherance of that purpose. Also, besides that point is, a lot of times when donors want to give monies to charities, they want to see what their practices have been over time. And so in order to achieve that, you now have access to these records. You're not just making a blind decision based off some proposal and documents that have been sent to you by the charity. You have a publicly accessible record of their statement of accounts, and you can make a decision that is more informed than prior to this time.
Yeah, so ultimately that could be act to the benefit of the charities, or I suppose they'd have to be more rigorous, make sure that they're spending their money wisely, including as they should be doing anyways, I suppose. But now having that public, you say, well, look, I'm interested in this, helping this cat and dog home in Aberdeen, but I just want to make sure actually it's spending its money for the benefit of the dogs, not just so that the owners can go to Crufts dog show in London or something or other, as part of their whatever the knowledge of dogs or something. I don't know if that would be, I don't know, it's not a good example, but you know what I mean. So you'd have greater confidence. Okay.
Absolutely. I mean, I generally, what charities should know is that the more rigorous regulation, the bottom, if you look at the general objective of the regulator, it is to ensure that public confidence in the sector is enhanced. And if there's more public confidence in the sector, then of course there's like I said, trading currencies trust, and then there's more donations, and the charities thrive a bit more. However, what you find down in England is that there's some level of deregulation somewhat, and empowering the charities to make a little bit more decisions than before, changing, for example, the governing document and things like that. Because also the reverse could be the case where there is too much rigor and too much intermeddling in the affairs of the charity, then it could now store creativity, store passion, and the charities with a clear passion for pushing a particular cause is expending all that energy trying to be compliant with some law. So it's trying to find the fine balance there to see how it goes.
Yeah, I mean, I was just about to ask that question, like, what is this all seems well and good, transparency and rigor are good things, but they come at a cost, do they, to charities? And if you're a small charity of under 20, was it 25,000 a year, it's the donations or some turnover? I don't know what that 25,000 figure is, but anyways, a smaller charity, if you have to produce complex accounts and hire an accountant and engage a lawyer or whatever else to do all this.
It's counterproductive.
Yeah.
It's counterproductive. So it's trying to find the balance of how this would work. And there are a few other changes, if I may, Paul. Do you want me to go on some?
Yeah, well, I think
we've
we've got about two or 3 minutes. You can summarize it.
I'll see if I can just touch on a few ones. One of the very key ones is the recording of charity mergers and the treatment of legacies. This is very crucial, a big achievement by this legislation. Because legacies prior to this time to a specific charity could be lost. It could be lost if the charity was wound up under the previous legislation, or under the 2005 position. Now, so someone could make a will, but does not include a provision stating that if the charitable organization ceases to exist prior to the state's death, then the legacy will be redirected to a successor charitable organization. And so what charities have done is that if there is some sort of successor one, they leave the existing charity almost like a shell charity in order to, it's open just to preserve and transfer potential legacies. But this has now been eliminated by the new legislation, and the impact of the merger we've now recorded, and it makes it easier. And that for transfer of legacies, I just touch on maybe two more in a minute. There is also the disqualification of trustees and key management personnel. So now the rule governing the disqualification of trustees and key management personnel have been amended. Now, under Section 69 of the 2005 Act, automatic disqualification was limited to persons being convicted of offenses in relation to dishonesty or an offense under the 2005 Act, or an undischarged bankrupt, or a person who has been removed by the Charity Commission down in England or courts of England on grounds of misconduct, and so on. However, this new law under Sections 4 of this 2023 Act, it requires that now there are more offenses like bribery, proceeds of crime, or certain terrorism offenses, or even certain sexual offenses, or when a prospective trustee is subject to a notification requirement under the Sexual Offense Act of 2003. So that's one. But a crucial one is that individuals who occupy senior management positions within an organization could also face disqualification as a criteria, because the new criteria has now been broadened to meet them, and the senior management function is one where the person is maybe not accountable to anyone, or is accountable only directly to the trustee. So this captures what was confusing in the past about the role of the CEO, because the CEO is almost at every board meeting, but somehow it's sort of not responsible for the decisions and so on. So now this captures CEOs or CFOs in relation to that. And lastly, Paul, is removal of charities Now, in the past, under the 2005 Act, a charity could be removed if the charity doesn't meet its charitable test. That was previously what was how they could be removed, or if a charity has applied to be removed and then it can be removed under that kind of scenario. This was problematic for the regulator because sometimes they send several correspondents, they send information to charities and there are no responses because these charities are even non-existent. And Oscar had no powers to do anything about it. But now they can remove people who have not responded to correspondence from the charity for general non-engagement with Oscar. So this is a good power that has been put given to the regulators. And there's a number of other changes, but I'm mindful of time. There's the issue about being connected to Scotland and so on. But I just stop here for now, and we could discuss some more if there are any questions or time for it.
Okay, excellent. Thank you very much. Yeah, we do. I think we've got a couple questions in the Q&A box, and I'll read them to you so everybody out there can hear them, and then you can have a go at making giving your view on them. So the first one, in the event of having the public interest as the aim for a charity, could there be a profit-making corporation which could set up a charity organization in an area of interest? And how would that conflict of interest be dealt with? So could a profit-making company, corporation, set up a charity in any area of interest, and how would that conflict be dealt with?
There are several of those kinds of things. I mean, sometimes, when you set up a charity, they could be set up in different forms. And one of the common forms that would fit this question that has been asked is a charitable trust, which is almost like a grant-making charity. So lots of organizations could set up a charitable trust, which function is, it is to dispense funds to a particular interest that they have. So the issue of conflict of interest by itself is not by itself a bad thing. It is how it is managed that is considered problematic. So if there is a potential conflict in any particular area, the key thing is whether it has been identified. And if it's been identified, steps have been taken to record, to manage it, to mitigate it, to see that wherever it's conflicted is not part of that decision making, and to see that the decision is made in as transparent way as possible. And lastly, in that process is recorded. So that's it. But if you flip it on the other side, if a charity wants to set up a profit-making organization. So this is where a charity is now trying to trade. It's different from, I think, the hypothesis of an organization, a profit-making organization setting up a charity. If the reverse were the case, then of course there's steps to take because there is some limitations on charities trading, especially where it is not a primary purpose trading. However, it is not an altogether no-no, but there is a process to follow. And oftentimes, if charities access would be put at risk in doing that, and it is preferred that you set up a trading subsidiary for that purpose, who would absorb the risk of that particular kind of trading.
Mm-hmm. That reminds me of the New Lanark case we wrote something about in the Scots Law Times. Uche, wasn't that the charity of that ran the excellent
the New
site
Lanark
in
case,
New Lanark.
They
set up was it an ice cream shop or a restaurant or something inside the New Lanark hotel or something? I don't know, but anyways, there was a question
with heritage, like a heritage conserve portrait kind of thing, and the question was whether it was a primary purpose, or whether it was not a non-primary purpose trade.
Yeah, interesting. That was a charity with a question rising around the charity setting up a commercial concern. So the opposite of the question. The final question for tonight. Many trustees believe their personal liability is limited by the charity's M&As, commonly to £1. Is this truly limiting their liability? And if so, is the concept of trustee liability worth anything?
Well, yeah. So this is what the gentleman is referring to is when you're dealing with a charitable company limited by guarantee. A charitable company limited by guarantee, you would usually limit their liability to about £1. It's similar to a company limited by guarantee, which also is a voluntary organization. It's a not-for-profit organization, but not essential, not necessarily a charitable organization. And that means that upon the winding up of the company, you can contribute to the amount of £1. It does not excuse. It's basic company law about liability being limited, but there is some concern where there's been some reckless, negligent behavior or fraudulent behavior that is not captured by this £1 limit or what which is emphasized here. So I think it goes back to the question you asked earlier about trustees' liabilities and the question of whether they've acted prudently and in the interest of the charity. So we have to be able to distinguish between this scenario and when a trustee has acted in a reckless and fraudulent manner.
Okay, excellent. Thank you very much. I think we're just about perfect timing. That just leaves me about 1 or 2 minutes to say something that Uche and I have been working on a short article on the changes wrought by the 2023 Act, and we're hoping it will be published in the next month or so. And when that is, I'm not saying if, when that is published, we will let you know, and Uche, of course, will publicize that. So and that goes into a little more detail, of course, and that we could cover in tonight, for example, about connection to Scotland, which we didn't really mention, but that's just in the process of happening, so we can't give any exact details yet, but we hope to have that to happen in not too long. So I guess I just want to say thank you, Uche. Very informative indeed. I loved speaking to you and appreciate your participation in our webinar series. And I think we're going out on a high at the end of 2023. I think it's been quite a successful event. So let me thank you, Uche.
Thank you very much, Paul. I really appreciate it. And thank you, everyone who took the time to join tonight.
Okay, so please look out for your email or your alumni office, and thank you, Colin, for helping behind the scenes in the alumni office. So, but thank you, everybody, and look out for your alumni emails and other correspondence from the law school, because we'll be beavering our way in early January, setting up the series for the first semester of 2024. So please look out for that. Okay, well, thanks again, everybody. Thanks for coming in. And have a great holiday season, and I hope to see you in the new year. Okay, bye-bye.